Here's what it means if a bond is held insufficient in a criminal case. A bail bond is a promise to appear in court. As a condition of being out on bond, there are certain expectations set forth by the court. They might be very simple, such as stay out of trouble, don't get arrested for anything else, and show up for your court appearances. That's going to apply to every bond throughout the state of Texas. However, the judge can also impose additional bond conditions based on the nature of the offense, a person's criminal history, the risk to the community, the possible risk to the victim. These conditions can range from things like providing a random urine analysis, checking in more frequently, checking in with pretrial bond conditions, which is really run by the probation department in Tarrant County. And it can get pretty restrictive. On some sex cases, you'll see restrictions such as a GPS monitor with exclusion zones. So there's a whole array of conditions that a judge can impose when a person's out on bond. A bond can be held insufficient for a violation of those bond conditions. So if you don't do something the judge asked you to do, or if you do something the judge told you not to do, your bond can be held insufficient. There are other ways that your bond can be held insufficient. If you miss a court date, your bond will certainly be held insufficient. If you're late to court, the judge can hold your bond insufficient. If your bondsman tells the court that you're not following the bondsman's requirements, your bond can be held insufficient. So a bondsman has the ability to file what's called an affidavit for release of surety, an AFRS. And the AFRS is telling the court you haven't done what the bondsman wanted you to do. And every bondsman has the ability to set their own conditions, just like the judge. So the bondsman can say, as part of our contract, you're going to call me once a week, or you're going to come to my office once a month. Well, in those circumstances, if you're not doing what the bondsman asked, the bondsman will file that document with the court, and the judge will hold your bond insufficient. When the judge holds your bond insufficient for any reason, a warrant will be issued for your arrest. So what should you do? Your first call needs to be to your bondsman, and you're going to ask the bondsman for what's called a reinstatement letter. A reinstatement letter says the bondsman is willing to stay on the bond, assuming the judge reinstates the bond. That will put you in the best position for us to make the ask for your bond to be reinstated. The bondsman may charge you more for that reinstatement letter, or the bondsman may say, you know what, I'm not willing to go back on your bond. You will not get a reinstatement letter. If they're willing to send a reinstatement letter, it needs to be sent to the court and faxed to our office, because we're going to be the ones making the ask. If they're not willing to stay on your bond or send you a reinstatement letter, then call our office and let us know. What will happen next is we will take you to court, and your position will essentially be that you're there prepared to self-surrender. That's going to be true whether we're asking for a reinstatement, because most judges require you to be in the courtroom or in custody before you ask for a reinstatement. But it will always be true if we don't have a reinstatement letter. If you don't have a reinstatement letter, only two things can happen. One, you get arrested on the warrant, or two, you self-surrender. So assuming we're being proactive and we walk you into court and you're ready to self-surrender, you have to go in with the following expectations. Without a reinstatement letter, the judge will almost certainly say, your client is being taken into custody. You can come back and ask me next week for a bond to be set. Sometimes we can get the judge to set a bond within a couple of days or a few days, but the norm in Tarrant County for our judges is if you don't have a reinstatement letter, your bond is held insufficient, you're going to go into custody. It'll be days or a week before the bond is set. The judge could even set the matter for a hearing, which will further delay when the bond is set. And the typical amount that the bond is reset to, particularly if there's not a hearing where the prosecutor is getting up and talking about even more aggravating factors, is for the judge to double the bond. So when you go in to resolve a bond being held insufficient without a reinstatement letter, you have to expect that you're going into custody, your bond is going to be doubled, and the bond will not be reset for a period of time. Now, if you have the reinstatement letter, there is a chance that when you walk into the courtroom, the judge will actually reinstate your bond. There's even an outside chance that we shoot for to try to get your bond reinstated without you being present. Again, many judges are going to insist on you being there, but we will try to get your bond reinstated if at all possible. Now, there is one exception to who you call first if your bond is held insufficient, and that is if you're late to court but you realize you can still get there the same day. So let's say you had a 9 a.m. court setting, you didn't show up, the judge said that they were going to hold your bond insufficient. Well, if you call us and you say, hey, I found a way to get to court, but I can't be there till 1 o'clock or I can't be there till 11 o'clock, you should still come to court. We will meet you there, and we will ask the judge to hold off on having the bond being held insufficient actually entering into the system. So if we can catch it fast enough, then perhaps we can avoid your bond being held insufficient. That only applies the same day. If you've gone into the next day and you haven't made contact with us or the court, then your bond is going to be held insufficient and you have to go through all the rigmarole that we just covered. A bond can also be forfeited. So once a bond is held insufficient and the warrant is issued, there's a period of time before the financial matters get finalized. So after a period of time, if you don't show up in court, financially the bondsman, or you if you put up a monetary bond, are going to be on the hook for the financial repercussions as well. That's what we call a bond forfeiture.